Hi, everybody, and welcome to Chapter 3. In Chapter 3, we're going to look at categories of law as they relate to security issues in the workplace. So, different sections of law are going to apply where there are safety or security violations in the workplace and where there are disputes between the employee and the employer. Also, there are security measures and legal standards where the hiring of security personnel are concerned. So, we're going to start with constitutional law, which is the branch of law that is concerned with the examination, interpretation, and application of all rights that are provided in the Constitution. The workplace has to adhere to these rights. They can't violate these rights in the workplace. There's also the criminal law that applies to security measures in the workplace. When security measures in the workplace are violated and there is serious harm, it may be a violation of criminal law. Criminal law is the body of laws that relates to crime. So it codifies what behaviors are legal and what behaviors are illegal, and it defines the sanctions for what happens when these behaviors or these laws are violated. The burden of proof for criminal law is proof beyond a reasonable doubt, which is required to convict somebody for guilt of a criminal violation in the workplace. That's a much higher standard of evidence and proof in order to convict somebody. And we're going to contrast that with civil law. Civil law in the civil court governs relationships between individuals and organizations, corporations, and governmental bodies. A civil wrong or an injury is known as a tort. You might have heard about this, in terms of tort law or tort reform. And a tort is a private wrong committed against a person or a property. If the party accused of the wrong is found liable, which means responsible, they must correct that wrong through monetary damages. This can be done by suing individuals or companies, and workers suing companies as a group in a class action lawsuit. So when there is harm or a security violation in the workplace and somebody ends up getting really hurt or somebody ends up getting killed, both of these avenues, both the criminal law and civil law, are remedies. The company, if they did not adhere to proper security measures, might be criminally negligent and could possibly become incarcerated if convicted, but they are also civilly liable, which means that the individual who was harmed or the workers as a whole can pursue them for monetary damages. Now, the standard of proof or the burden of evidence in civil law is not nearly as high as it is in criminal law. The reason it's higher in criminal law is because you're risking your freedom, but in civil law, you're just risking the loss of your money. I mean, I know that's just risking the loss of your money. It's still a big risk. But as a result, in the civil court, you only need preponderance of the evidence, which is basically saying whichever side has more evidence for their case. So if the person suing has more evidence that you wronged them or you were negligent in workplace safety, then they're going to win. If the company getting sued can present more evidence than the person suing that, no, we did all of our due diligence, we provided all safety and security measures, then they're going to win. But let's shift gears and talk about negligence torts, because this is a common issue where lack security exists in the workplace. Negligence torts occur when there's a failure to carry out specific tasks and activities that result in the harm or the loss of another. So, for example, if an employer fails to meet OSHA requirements and someone gets hurt or killed on the job, that would result in a negligence tort. I want you to be aware of something called respondent superior. And respondent superior is the legal standard that holds employers responsible for the actions or the failures of an employee when negligent. So, in other words, a quick way to say that is, I'm an employer and I hired somebody, and the person I hired did not it's their job to make sure that those security measures are taken in my workplace, and they did not take them. I am responsible for that liability. If the person I hired isn't doing their job, it's my job to make sure they're doing their job. If they're not providing safety and security, it's my job to, make sure that they do and or fire them and replace them with somebody who will. If they don't and someone gets hurt, I can be held liable as the employer, even though it's not me specifically who is shirking the security measures, but it is my employee and I am responsible for them from a legal perspective under respondent superior. There's also intentional torts, and these are civil wrongs that were intentional rather than accidental or negligent. And let's talk about some of the ways that torts are remedied. So we know that in the criminal law, if somebody violates security measures and someone in the workplace dies as a result, the way that is remedied is somebody goes to prison, right? But in torts, nobody goes to prison. But there are a multitude of different sanctions if you are found liable as an employer because you did not provide proper security. So the first is going to be compensatory damages. And that is when the plaintiff is going to receive compensation in the lawsuit for the losses they incurred. Excuse me. So, I couldn't work for 3 months because I was really terribly hurt on the job because you didn't provide safety. So you have to pay for my wages. There are also punitive damages, and these are going to be monetary awards that go above and beyond the losses or the harm experienced by the harmed party. So punitive damages are going to be paired with compensatory damages, and punitive damages are exactly what they sound like. Excuse me, they're meant as punishment. It is basically a punishment to say, hey, not only do you have to compensate the person for their time lost, their wages lost, the money they lose to medical care for the damages they sustained, but we are also going to punish you by making you pay a punishment fee, essentially. And that is to deter the party from repeating this negligence in the future. We want to punish you. We want this to be a, economically, air quotes, painful experience so that you don't do it again. There are also injunctions. Injunctions are judicial decrees by a court that a course of action or conduct has to cease in the workplace. So a court can evaluate the circumstance and look at the employer and place an injunction over certain behaviors or activities, etc., that you must stop this immediately. So let's talk about some defenses to tort law. So the first is assumption to risk. And these are going to be the defenses that are put forth by the companies that are getting sued. And they're going to say that, hey, the person who works here, the person who got harmed or what have you, takes on an assumption of risk. And that is when the plaintiff knowingly and voluntarily assumes the risk of the activity or the action that resulted in harm or damage, which therefore alleviates the other party from liability. That the employer is going to say, you knew that when you signed on for the job that there are certain risks, you assumed those risks by accepting the job, and therefore the risks that could result in harm, that in this case did result in harm, are not our responsibility. We don't have to pay for that because you knew what you were getting into. There's also comparative negligence, and that is when the plaintiff did something that contributed to their own damage, injury, or harm that was incurred, therefore alleviating the employer of that liability. Saying, and the defense here is saying, hey, the reason you got harmed on the job is because you weren't following our safety protocols. We have our safety protocols in place. We have taken all proper measures under the law. You were not adhering to them. Then you got hurt. That's on you. We do not have to pay for that. I also want to shift gears and talk about administrative law. And these are agencies that are given powers to enact rules and regulations that govern organizations. They're given this power through laws such as regulation of education, regulation of taxes, regulations of consumer protection, regulations on transportation, etc. And the reason that all of these regulations are put into place is for the safety of everyone involved. That companies and organizations can't just create products willy-nilly, cut corners, cut costs, and then put everybody at risk. That's the whole point behind administrative law, is oversight to make sure that companies are being responsible, that they're doing their due diligence, and that they're not causing harm in order to save money or out of irresponsibility. So we're talking agencies like the IRA or OSHA, which we talked about already. These are administrative law agencies, and they have the ability to investigate and prosecute organizations that are found to be in violation of those regulatory statutes and requirements. So security personnel are going to fall under this category, specifically because they're required to undergo a certain amount of mandated training and pre-employment standards in order to be able to work. You can't just hire any random person for security. They have to meet certain requirements and go through certain trainings. And finally, I want to wrap up this chapter talking about different kinds of contract law. So contracts are legally binding, and they are voluntary agreements that both parties enter into of their own volition. They both agree to do something or to not do something. And if that contract is violated, the injured party has recourse in civil courts, which we've already discussed. There are different kinds of contracts. So the first is going to be an express contract, which all terms are explicitly stated and detailed throughout the contract, and both parties agree upon those. There's also implied contracts, and those are unspoken contracts where the parties believe an agreement exists. There are e-contracts, which terms and agreements utilize a website as a service. You have signed hundreds, if not thousands of these every time you go onto a website, and there are the terms and conditions using the website. You've never read them. I haven't either, but we all click the little box that says we have read them so that we can gain access. These are treated the same as paper contracts or express contracts in terms of legal responsibility. There's also something in the workplace that has been highly controversial called non-compete agreements. And this is a contract where an employer will require an employee to sign, um, a contract stating that, when I leave this job or if I'm fired from this job, I will not work for a competitor. I will not work for a specific period of time or in a specific geographic region where it would create competition for the employer that I'm signing on to. This has been recently litigated in the courts, in the high courts, the appellate courts, as to the legality of this. And finally, I want to talk about the Private Security Officer Employment Authorization Act of 2004. And this is an act that prospective employees may conduct employers may conduct criminal history checks on any applicant pursuing employment in the security services. When they do this, employers get a report from law enforcement agencies about whether or not that individual has a record, but that record, if they do have a record, of criminality, the prospective employee does not have access to the specific details of that record, but they do get notified that yes, this person does have a record, which gets back to what we talked about, that administrative law with hiring security personnel, that you can't just hire anybody, that people, providing security have to meet certain criteria, and one of those criteria is that they don't have a criminal background.